You need to know this: do not give up on your legal status. Many people fail to respond to RFE or file an application before the deadline. This is why we offer a strategy session for 15 minutes at no cost to you. Not everyone qualifies. First, you need to speak with our CARES team. We receive many requests, so we recommend you answer a few questions on our website, greencardguys.com. Our mission is to help people live and work in America legally. Go ahead and subscribe below and follow and share. Talk to you soon. What's going on? Today's topic is about removal conditions. Okay, folks, this is a very, very important topic because some of y'all forget about the red flags. You don't know about the red flags, so I'm happy to share about it. Lately I've been going live for about 30 minutes to an hour, but today it's probably going to be on the shorter end just because I got my kiddo at the studio. Okay, so he's not feeling too good. And hopefully he feels better soon. But let's see here. Yeah, some things you need to know about removal of conditions is that it's necessary for most of y'all. Okay, if you've gotten married and you applied and you got married, let's say like a year ago, but you applied fairly recent within that time period, because of course everyone wants to get status as soon as possible. This video is for you. Okay, this show is for you. Now, of course, I'm happy to answer any questions to the best of my knowledge, and I try my best to answer many of them, but to be honest, I won't be able to answer all of them. Okay, so if I am able to answer your question, but you're looking for a little bit more in-depth answers, and which is generally the situation, or I'm just not able to get to your question, please, you're welcome to contact us, at least on YouTube and Facebook. You can check it out up here. TikTok, I don't think I'm allowed to share it, those kind of personal work details. So I was banned for like 5 minutes a week ago. So please go ahead and go to our website, greencardguys.com, to find our information. All right, folks. By the way, if you've been on a show before and you appreciate the way we share information, just our advice, well, I'm not supposed to call it advice, it's information. That's my disclaimer, or every attorney's disclaimer. But it's point you in the right direction, trying to help you solve an immigration problem, maybe even prevent it from happening in the first place. Okay, folks. So I've been trying to figure out this angle thing for my camera and this the camera for the YouTube. So if I'm looking down on YouTube, apologies. Okay. Let's see here. All right. So the thing about remove conditions, okay, is that if you've been married and you haven't received your resident status, if you received your resident status, let's say like today, but it's been less than 2 years since your marriage date, then you're going to get the conditional resident status. Now, if you've been married for much longer, and by the time you finally receive approval of the resident status adjustment of status application, then it's going to be a 10-year resident status, which is great. That's honestly what you prefer, of course, so you can skip that next step of this, what we're talking about today, remove conditions. But our case experience, most people end up getting the status, the resident status, within that 2-year period. So you're going to get the conditional resident status. So the next rule in knowing that is that you have a 90-day period before your conditional resident status expires, which is for 2 years. So basically at the 21-month mark to the 24th month mark, you need to file this application, 751. Okay. Now, what happens if you don't file the application within that time period? It's still okay. You can still file the application, but you want to file it ASAP before USCIS refers your case to the immigration court, right? Because if you get immigration court involved, of course, you're going to have to pay an attorney much more. And of course, it's better to have an attorney lately in 2023 and, before we're able to get these cases dismissed, fortunately, but not everyone, right? It depends what happened in your first marriage or your prior marriage anyway, how you got the green card. Because some of y'all just don't see eye to eye anymore, and then you get separated, or then you get divorced, And some people, some things that some common scenarios that people have is that, yeah, you get separated, but maybe you haven't filed for divorce yet. You're waiting for your spouse to file it because you don't want to suck up the money in terms of just paying the filing fee or paying a lawyer. Not that you need a lawyer to file for divorce, but again, just like immigration, it's always typically better. So you could get as smooth process as possible. And we know contacts in other states, by the way, if you need one, need a divorce lawyer. But I wish you the best in that, of course, but in your marriage, but this and divorce proceedings. But then there's always such a lot of scenarios where people are separated, unfortunately, and what I mean separated, by the way, is that you could be still living together, but you just don't see eye to eye. Yes, of course, it's arguments, disagreements in a marriage or any kind of relationship, right? But it's just broken down. You're not able to communicate anymore to where you can have some kind of agreement in general, right? Even if it's like, where do we go out to eat? Of course, the arguments are going to be way more serious than that. That would cause a divorce. But yeah, so USCIS still will approve your case even if you're divorced. And yes, hot tip here, if you're in this situation, or you could be in the future, is that the instructions state that you need a divorce order. Makes sense, but that doesn't mean you cannot file your application if you don't have a divorce order. You can still file with some kind of proof that you've started your divorce case. So in Texas, we call that a petition for divorce. All right. I would suspect in most states, they would probably call it something similar or like a complaint, something of that nature. But you just want to send something with the 751, okay? It's very important. And even though you may be divorced or you're separated or just had a divorce case started, you still need to provide evidence of bona fide marriage. Very, very important. If you don't have any of that, good luck. Okay, good luck. I wish you the best. But so that's a hot tip for the future. Of course, you can't predict the future. At least I don't think you can. Maybe I'm wrong, but just some things you should think about. And maybe it's not for you specifically, but you have a friend or a coworker, a neighbor who's going through this immigration process. Then who knows? Maybe you could let them know. Of course, some people like yourself, if you're not a lawyer, may not feel comfortable sharing legal advice, and that's cool. You know what to do. Just share a video, okay? Share a channel. We would greatly appreciate it so they can get the information straight from the source. All right, so now I have a lot more to share about that, but let me get straight to the questions today. All right. By the way, if you, I usually talk a lot longer before answering questions, but if you're just now joining, my printer's making a noise. Okay, that's weird. All right, let me disconnect this. Just gonna disconnect that. All right, so first question: is it a problem if I write the wrong citation date on the N400 during the interview? No, I mean that's not gonna necessarily mean it's gonna be a denial, but you definitely want to update, okay, the officer when you go for the interview. There's no reason to lie about that, right? Okay, hopefully that helps. Let's see. Next question. Let's see what else. By the way, in the meantime, at least right up here on YouTube and Facebook, you find this number up here. You can access just in general. Y'all on TikTok, I forgot to turn on the Instagram one, but y'all have the access of a strategy session for 15 minutes at no cost to you. And you need to provide the secret code. If you want to be prioritized, or at least our CARES team specialist can help try to prioritize your inquiry request, okay, your consultation, you got to share the secret code. All right. The code is TLG. All right. Every day is a different code. So today's code is TLG. If you don't want to forget it, just DM us or send us a message, text message, TLG so you don't forget. Because we do get a lot of inquiries in our request for consultation, of course, for the no cost to you, the free 15 minutes. And it's hard, it's difficult. Some people we have to say no, just because we don't think we could help anyway, even to point the people in the right direction. We just, if that's the case, we'll just email you a free guide if we have one that applies to your situation. But for the most part, we're able to provide some guidance in a consultation, of course. So hopefully that gives you an idea. All right, Jade, can you send your request for evidence a few days before deadline? Oh yeah, absolutely. I mean, you want to make sure they receive it before the deadline or on the day of the deadline. But I recommend not risking it. So if, like, for example, you're waiting for one particular document, really just have it in your calendar, set it on your calendar as an event or a due date so you don't forget. Okay. For us internally, we even like um, prepare mailing labels in the office, so we don't mess around and just go to the post office, FedEx, and just wait in line. Like, we don't got time for that. We got. I don't think any office, hopefully no other office does that, in waiting in line. But so those are some examples. Like, if you do that, there's something called like pirateship.com. So you just don't have to wait in line. It's pretty ridiculous. Um, But hopefully that answers the question. Yeah, in general, you can submit it a few days before, but you want to make sure they receive your package on that date or before that date. Okay. Is it hard to claim your spouse from Nigeria? What do I need to do? It can be difficult, but we have successful stories. But it's difficult for a couple reasons. Number one, the U.S. government leans towards discrimination, unfortunately, but that doesn't mean they won't approve your case or issue the visa. But the first thing you need to consider is, does your spouse have a visitor visa? All right. I'm not trying to tell you what to do with the visitor visa, but if he or she already has a visitor visa, then that's good. But it sounds like you're already married since you used the word spouse. So, but anyway, DM us so we can share more information to you specifically. Okay, Cruz, and then so that would be the first question to consider. But otherwise, generally speaking, when a person is abroad, a spouse abroad, you don't have to have so many documents in terms of evidence of bona fide marriage, because in general they don't expect you to have a joint bank account when the other person's abroad, right? Because usually every bank, from my understanding, the other person needs a sign to join someone's account. All right. Girl power, what's up? More power to you. Hello, you ended your marriage and your remove conditions is coming up. Okay, so exactly what I was talking about earlier. And so you want to file, if you haven't filed yet, you said end of your marriage. So it sounds like you already have a divorce order. So you definitely want to provide a copy of it. Make sure it's certified. It doesn't have to necessarily be the original certified one, but at least some kind of stamp or seal. In Texas courts, at least the ones of the urban courts, county courts, they have a seal. I think Harris County has it on every page, and then Dallas County is like on the last page. So, but it doesn't have to be on every page as long as you have it somewhere. Okay, on the photocopy. Hopefully that helps. I don't know if I answered your question, Lorena. What happened with your job and driver license while you're waiting on removed conditions? Well, hopefully your HR doesn't ask you for your updated work permit, if that's what you mean. Maybe your job is related to driving. I'm not sure if that's what you meant, but because if you filed an application 751, then it's supposed to provide you a receipt notice that has auto extension for 48 months. So that's for 4 years. So there's good and bad to that. The good thing is that you don't have to call the USCIS, say, hey, I need a stamp, or I need proof that I have conditional residence status right now, because that was a pain in the butt before this recent change. But the other flip side, the negative part, is that 48 months, why would they do that? That goes to show that USCIS has finally acknowledged that for some reason the processing or the adjudication of 751 applications take forever. Forever. I don't know why. It's too long. It's not necessary to take that long. Yes, if you're still married and you have sufficient evidence, then if I was the government, just rubber stamp it. Okay. No, I'm not saying paper, rock, scissors. That'd be too wild to make a decision with paper, rock, scissors. But what I mean by that is it should be rubber stamp. But no, the government wants to make it difficult for you. So we do have a hot tip I want to share in a bit. Maria answered that question already about the citation. Just update at the interview. Let's see. Let me hop over to. Okay, Amanda Tucker, you're engaged to someone abroad, and best way to come to U.S. to get married, K1 or visitor visa. Of course, I'm not, as a licensed immigration attorney, I can't tell someone to violate immigration laws to overstay, but I can tell you we have many successful stories among my colleagues as well for someone to obtain resident status with someone, the sponsor is a U.S. citizen. Okay. If the sponsor, Amanda, I'm going to make a safe assumption that you're the sponsor. So, but if a sponsor is a resident, then I definitely wouldn't enter with the visitor visa and overstay, because it's a different negative consequence. Still rectifiable, still can cure it, but the main thing is if someone's a U.S. citizen, sponsor, spouse, then it waives unlawful presence for the beneficiary, for the immigrant, foreign national. Okay, so hopefully that helps, Amanda, and anyone else in a similar situation. So I can talk more about that. One of our associate attorneys can talk more about that. If you want to access, give us a call, a strategy session at no cost to you. There is no obligation to hire us. Of course, it will be our pleasure to assist you from start to finish. Or if you're in the middle of your case and you don't like your other lawyer, that tends to happen. We get a lot of calls about that, unfortunately. We're very intentional about our customer service. You can check out our over 300 Google reviews. We're very fortunate that people care enough about us to write a review. So, and our team is very, very intentional about customer service. And it all dates back to, goes to our vision statement and mission to help people live and work in America legally. Okay, so anyways, let's see. Another question, Carlos. Does USCIS still use the 90-day rule for AOS? Even if they don't, I use the 90-day rule. I prefer it because it dispels any kind of, what do you call it? Like a mindset of the officer, and it depends on everyone's situation. It goes to the 90-day rule is based on intent, right? But it's also in our preparation for clients, it's also about gathering evidence of marriage, right? So this could be difficult if someone just got married recently, right? And but yeah, I get it. You may have been married before. I mean, not married, but been dating before and maybe had a joint bank account before. But 90-day rule about intent, we recommend to wait the 90 days. Okay. And it depends. Like some people may already be on an F1 student visa. We had a conversation with a person yesterday about that. So we do recommend waiting. Okay. But in the meantime, you can go ahead and gather the evidence. We can share with you our proven checklist when you're a client, things like that. Okay, Ford, your son's filing has been approved since March, but no interview date. He's in, you said, I'm assuming Jamaica because it says JA. Yeah, you said it's in March. When you say approved, you talk about the petition. So there's a couple steps after the petition, I-130. You need to get a new case number. You don't request it necessarily, but National Visa Center, the new way of doing it, where they give you a new case number, is by email. Okay, so if you haven't received that yet, then you definitely need to Google search contact NBC or something like that. Okay. We're happy to take over on that case if that's the situation. But hopefully you have the case number, because after you get the new NVC case number, you have to upload financial documents, whoever the sponsor is, I'm assuming you, and then you have to get documentarily qualified, which is when you provide everything that they asked for, the government, then usually about roughly like 2 to 4 weeks, you'll get another email saying the update, your case has been updated. Go check the portal, the CEAC website. So then you can check it out to make sure, because I don't think the email actually says documentarily qualified. That would be nice to save everyone some time. And then after that is the interview. But in between documentarily qualified, which a lot of people call short DQ, to the interview date, it can be an average like 6 months to a year on average. And some people have been waiting more than a year. So it's super frustrating. And that's when we definitely recommend to file a mandamus lawsuit based on unreasonable delay. But for example, if you say March and you already upload everything, it's still too early to file a lawsuit for that. Okay. But if anyone has been wondering, I don't know if my case has been delayed long enough, don't worry. DM us, ask us, tell us the dates, tell us what application you file, and we can give you a better idea. Okay. A lot of people, our CARES team specialists are trained to tell people no, actually, sometimes, or every time when they haven't met that threshold that we put together. What cases we work with, Beatrice, Nancy, you asked, we actually currently do not accept asylum cases, if that's what you're asking about. We don't accept asylum cases anymore for last couple of years. We've been referring out to, for example, Brian Manning. He's one. His law firm, Manning Asylum Law Firm, is someone you could consider. He's on TikTok and YouTube. Check out his videos, and we're of course happy to share his information. If you DM us, you just type in Manning or Brian, and we'll send it to you. Okay, but he's one example of many lawyers that we refer to, great attorneys. But his law firm only handles asylum. So I think usually, for most people, that's a good fit. All right, Arius, nice to see you again. I think I remember your prior question, or I remember you joined the live show before. Okay, you apply for AP to visit your grandma. Will they ask for her birth certificate? I don't think I've ever had that come up actually for proof. If we want some proof, like I don't know if you're. Hopefully everything's well with your grandma, but typically if they approve AP, I don't know. I don't remember what you have. Like you have 485 application on file pending, or DACA or TPS, but usually DACA or TPS are filing based on that. They're pretty specific. Okay, that they want more. They want a specific reason why you want to travel abroad, which shouldn't matter, but they do ask. It matters because it's on the instructions. So I don't know your basis, but yeah, they could ask for the BC, or if you're saying for example, if your grandma's on her needs, is in the hospital or clinic, then they could ask for proof of that. But we've had clients approve for AP when it's a memorial or a funeral, but maybe the funeral happened several years ago, and now it's like more a memorial, so that's worked out as well. Okay, but of course your grandma's living, so that's good. Glad you're trying to visit her. USCIS showing name was updated. What does that mean? Viable case. That typically means that if maybe you hired an attorney, or if you have an attorney, then USCIS finally updated it, which every time we've seen that, that's what it means, that we entered into a case. Look, this is a good example to share with y'all that USCIS is not that detailed, I guess you could say. I was going to say accurate, but they're not that detailed in the update. It could be something else, but typically when we've seen it, it's because we entered into a case. So it would be nice to be more specific and say your attorney joined the case or something, entered into the case. But I think they just have some generic case updates, and I don't know, maybe like five to six. So they just, yeah, they don't want, they want to make it as easy as possible for them, but not us. Okay. All right, Drick. What if you get RFE regarding affidavit support, but it doesn't tell you what they need? What? Well, that's crazy. Well, typically, if there's RFE on 864 for the affidavit support, it's because whoever the sponsor is, their income does not exceed the minimum poverty guidelines. Okay, so check out Google search 864p and just double check that. We do have a video on YouTube about the other options on how you can assets and things like that, but I can't cover it in this live show. There's too many. It's a long conversation. You will contact us. Haven't gotten any numbers. Okay, I'm willing to share the number, our phone number. Is that what you mean? I'll share it right now. Please, like, write it down or use a pen, something, because I think TikTok doesn't like us people sharing. But the number is 720-740-4247. Okay. Otherwise, if you didn't catch that, go to greencardguys.com and all the information is right there. We have a couple different numbers, by the way. So, yeah, just save the number whenever you get a call. Appreciate it. Thank you for asking. Or DM us. Okay, the secret code today, by the way, folks, to unlock the strategy session for free 15 minutes and to get prioritized. The secret code, what did I say earlier? TLG. TLG is a secret code. I need to share that with the team right now. Secret code today is TLG. Okay. Jay, can you send request twice? I don't know what you mean by request. Do you mean response to the request for evidence? You could, but has it been a long time and they haven't updated online saying that they received your RFE response? They typically do that to update the system online, but they might not be that quick. I mean, fortunately for us, when we are intentional to check, it would update it. So if you just sent it off like 2 days ago, then maybe wait a couple more days. Honestly, I would just probably wait a week before sending it again, unless you're like, now, if you didn't use tracking with delivery with tracking, then you might want to send it before a deadline again. Okay, but always, for y'all who are filing your own case, always mail with tracking. USPS Priority or Priority Express, whatever they call it now, or USPS or FedEx. Make sure it's with tracking. Now, requesting a signature, I think that's maybe a little overdoing it, but if you just want to make sure with that, that's fine. It's not required, but at least a tracking number. Okay. What about us? Let's see. Oh, okay. Anu, I see your question on YouTube. I did make a video. I'm trying to do something where people comment on YouTube. By the way, YouTube doesn't make it that easy to record a video like TikTok. So what I'm doing, I'm having a team basically re-upload the video to YouTube. I shouldn't say that out loud, I guess. But so Anu, your answers to your question will be coming soon. Okay. Emily, your other question here. If your case at NVC waiting to be DQ'd, however, you also filed a 45 with approved I-130. Okay. Are you allowed to keep both while waiting? Well, Emily, are you here on, I don't know if it's you or someone else, but because I know you asked for your homies, but do you have non-immigrant status right now? And I think you have a spouse case or something. Are you or your spouse a U.S. citizen? So, that's going to be confusing for the government, because on the I-130, I'm glad you're sharing this now. The I-130 has a question. I don't know, like towards the end of the form, like what do you intend to do? Do you intend to consular process abroad or adjust status in America? So Emily, I don't remember your exact situation or who's the sponsor and the sponsor status, but if a person enters, so this is for really anyone in this kind of situation, if the immigrant enters with a visa and the sponsor is a U.S. citizen spouse, so this family-based case, then you don't need to. You want to make sure on that petition that you put in like your local USCIS field office, typically the urban city near where you live, but you can always Google search it. You would put that office. You wouldn't put your embassy or consulate of your country. Okay. Now, however, let's say if you enter with a visa, but your sponsor is a resident and your sponsor spouse does not intend to become a citizen, then you want to pick a consulate or embassy in your country of nationality normally, unless you apply for asylum. The other flip side is you also need to do that, select the embassy or consulate if you entered America without a visa, because then you also need a waiver. Okay, so that's like immigration 101 basically. And if you didn't, let's say for example you do qualify to adjust status in America, but you had already selected a consular embassy on the I-130, they're going to send the case file to the National Visa Center. So you're going to have to file another form called I-824. I don't remember how much it costs, at least $500, I assume. So it forces another government agency to send a file to USCIS. So, yeah, I don't know. Hopefully you're okay for yourself, Emily, on that one. But there's a lot of people that have similar situation. The person is in legal status, stated consular processing. However, they also want to do AOS marriage. Person's a citizen. Okay. So, so if that's the case, and that person is likely able to continue maintaining status, non-immigrant status, then yeah, they're gonna have to send an 824 unless somehow they can send in the like a letter to USCIS saying, "Hey, can't move it over." But I haven't tried that like that. Every time someone's asked this move, it's already been too late. But you did mention earlier in the note that the petition's approved already, so it's probably too late to just send a regular letter. Are they allowed to keep both? I mean, it's not really about allowed. The case file is in one location, so you can move the file. It's just, I don't want to call it complicated, but it just costs more money. So if the petition is already approved, then, and the sponsor is a citizen, sounds like they're just waiting on nothing. Like if they're just, it's a little bit confusing. You might want to have your friend just schedule an appointment with us, because you said the petition approving the sponsored citizen. You can file the 485. Like, what's going on? Why are they waiting? I would just rely on the 45. Why would they even consider doing the consular processing? So, but yeah, but yeah, and if the petition mentioned a consulate or embassy, they need to make sure they mention that in the letter that they want to change it back. Maybe they could do it, change it over without the 824. I'm not sure. Yeah, okay, so it sounds like they already filed it. They're waiting on the approval. So hopefully USCIS knows to have kept the original file with USCIS and not moved it over. Hopefully. Okay. Good luck to your friend. Sing. You got RFE after 2 years applying 751. Sent the RFE back 4 months ago. A response. What can happen? Maybe nothing, unfortunately. It might just sit there for a while, but I'm glad you responded to the RFE. And just because USCIS is lazy, they don't have as many people working in general. I think because of the pandemic. And yeah, what else can happen? Yeah, you just have to sit tight. Really, it's not much else to do. The only other thing to do is file a lawsuit. But it's 4 months. I'd probably wait at least 2 more months. Okay, and then give us a call, or you can DM us now. The secret code TLG. If so DM us the code TLG especially if you're busy at work or you're driving. So do the speech to text. But yeah, so you can access those as a strategy session because you might not be eligible now. We might recommend, in general, for others. We might, even if you want to contact us now, that's okay. We might not recommend filing now in general, but maybe it could be like a couple months down the line, just depending on your situation. Okay, you're on H-1B. Your mother wants to stay with you long term, not just tourist visa. I think possibly you asked a similar question the other day about visitor visa, but now your question is a little bit different. Long term, yeah, she wouldn't be a parent is not considered dependent for H-1B purposes, like H-4, unfortunately, only a spouse or children. So unless your mom's willing to be sponsored, like for EB, but even that would take a while. Okay, so does your mom have a company abroad maybe? Or thinking about opening a company? They can come here on L1 visa. It's possible. Or depending on your country nationality, maybe eligible for E2, E1 visa. They call it trader visa, but I like to consider it like a startup business. Or it doesn't have to be startup, but you have a business essentially. But depends on your country and nationality. Okay, Cody Fools. Can you file for citizenship with your husband being in jail with a pending 71, been married for 4 years? I believe so. I haven't read anything that you wouldn't be able to if a spouse is in jail, assuming your spouse is a U.S. citizen. If so, I guess let's see, because your spouse doesn't have to sign anything about that form, the N-400. So that's a good thing. It's only the foreign national, or I mean, I guess not foreign national anymore. The resident is the only one that needs to sign the N-400. Okay, but it does ask about, of course, marriage, if you're divorced, married, the address, things like that. Let's see here. Okay, let me go back. Okay, I have this comment. Brenda Olvera. How much time does it take for your husband to get the residence once you send all the documents? Well, sounds like you haven't filed anything before, so this is like fresh case, brand new to this. So it's I-130 and 485 if he entered with a visa or qualifies for exception, then you can file the 485 application among a couple other forms. And it sounds like marriage case, then you can 2023 you can get it approved in 3 to 5 months on average. Some people it's less time than that. But yeah, if you want to give us a call, we're happy to point you in the right direction. Okay. Let me answer. Hopefully, it answers your question. Let me hop over to YouTube. Fidel. Updates on stateless people. Any update for U.S. forgetting about people? I think you mentioned a question the other day. I'm sorry, I don't think I answered it. But yeah, it's just difficult. I don't know your situation, but I think it's been difficult, of course, for people to get some kind of status. And then, especially, I think for asylum, that's even more difficult because then the judge is trying to figure out, which country of nationality you have, right, that you're claiming fear. So, but I don't practice asylum. So, anyways, at least not anymore for now. But your question is too broad. I need to know a little bit more information for me to. And the best thing to do, is just contact us, and we're happy to try to research for you, depending on the question. Of course. Let's see. But by the way, when people need more substantial research, we do charge money for that. So keep note of that. But usually not everyone requires that. Usually if it's extensive when it's like a crime. So there's immigration consequences, of course. All right, Fidel, what happens when you lose your case and the appeal got dismissed? You still have a deportation order, but still have to go in and sign at the ICE office. So you can file an application called stay of removal. And that actually, if the ICE approves it, then you can get a work permit. Many people don't know this actually. So I recommend doing that at least because in general, this is something that every president tries to do is like if you have a removal order, deportation order, the goal of the U.S. of ICE is to execute on those orders, meaning remove you from the country. But they tend not to do that all the time for everyone because they don't have that many people working, right? So But I highly recommend filing a stay removal application, and I highly recommend not doing that. Like if you don't have anything prepared, don't just show up to the office without anything, okay? Because you just never know when you have a mean ICE officer meeting with you and they execute on the ICE, they're basically like ICE warrant, essentially the deportation order. So just keep that in mind, okay? And by the way, I do hear a lot of requests. Our associate attorneys are on our premier attorneys on our team. I've been getting a lot of requests for appeals. We're very, very strict on which cases, which people we're able to help with the appeal. And it's not based on people, it's based on the facts of the case. All right, we're very particular on that because if we believe that there's no benefit in filing appeal, like someone gave us a 3-star review the other day because we told them we can't help them on appeal. I think that's honestly ridiculous. So we need to give him a call because his deadline was like 2 years ago, and he already had another lawyer. He had 2 lawyers file an appeal. So I think that's a little strange to give us 3-star because we told you it's already, you know what I mean? So you got to be realistic with your situation. Or not a type of attorney that's a law firm that's going to just accept any case. All right, we appreciate that you consider us, but that's honestly why we don't offer free strategy session for everyone. So that's honestly a little upsetting, but as you can tell from my demeanor right now. But anyways, can I talk about Taurine? Can I talk about U visa? Absolutely, happy to talk about it. But it helps when you have a little bit more specific question. But in general, if you have been a victim of a crime, you don't actually have to know the person. Could be a stranger, could be your neighbor, a friend, your significant other. If it's your significant other, you don't actually have to be married to that person. If you were married to that person, then that would be for VAWA, I-360. But U visa in general, it's a long road ahead. But a couple things you need to know beforehand in terms of initial steps is that if something happens, do not be shy to call 911. It is always stronger when you have a police report, okay? Because it's the common proof. Is it required? No, because for some reason, if you don't call 911 at that on that day of the incident, you can always go to a police department later. So even if you haven't called 911 and it's been a couple weeks, make sure to go to the police department. You don't have to speak with a lawyer to prepare you, but it certainly could help. Of course, number one, you got to tell the truth of what happened, but you don't want to delay on filing a report. Okay, it's very important. So 911 is the most common, but you know, if and here's the deal. Here's why. Because the legal requirement for U visa, aside from the forms that you sign and our office would prepare, the 918, there's also another form called U visa certification. Okay, so the U visa certification is signed by essentially a government entity. It's the is a designated person, but it's either someone at the police department. It's not necessarily the detective on your case or investigator. It could be someone in the police department. It could be sheriff's department. It could be if it's sheriff's department, typically only if, of course, they've investigated the case, not just randomly. Um, let's see, a judge, if the case has gone to the criminal court, a judge, or the district attorney's office. Okay. Now, again, it cannot just be anyone. It has to be a designated official for U visa purposes. And the reason behind that is because they have to be trained on this. So because some people, first of all, think that if they sign the form that they're just granting U visa. Honestly, I wish that was the case. Could shorten the timing from like 5 years to 1 year, but that's not the case. So some people, law enforcement officials, may get confused. Ms. Frazier, how long does it normally take USCIS to produce EAD? It depends on your case type. I need to know the basis of your application, but I was assuming it's marriage because that seems to be a common one. Then 2023 trend, you might actually get the green card before the EAD, but an average five months. Okay. Let's see. Okay, I want to answer a question on YouTube. All right, App Kim, welcome back. You've been in the process of AOS with USCIS since September 2022, so it's almost a year. You recently, one of your parents passed away. Our condolences to you, App Kim. You requested USCIS to expedite your I-131, which they've approved. Okay, great. I thought maybe that's what we talked about the other day. There's who is a U.S. citizen? Okay, in spring, today, except for the green card, you have all documents that you need to live in the U.S. as a tax-paying resident. You have social security number, work permit, and driver license. Okay, let me skip all the way down to the bottom to your question. Your concern is that I would be denied re-entering the U.S. because you overstayed your visa. Well, you have if you have advanced parole and you re-entered or you're about to re-enter, if your advanced parole is valid, then overstaying is not an issue. Okay, it's only an issue if you have arrest and convictions. Then we should have talked to an attorney before leaving. So it sounds like you're already outside America. Um, maybe. Well, if you're not outside America, yeah, then and if you have arrest or any kind of criminal history, you definitely want to speak with an attorney sooner than later about that. Okay. Um, but yeah, even if you overstayed, that's okay if you don't have any arrest or criminal history, as long as you have approved AP, which is what you said, and you re-enter before it expires. You don't know if your status is considered unlawful or considered unlawful or not. Yes, it's unlawful. It's overstay, but that doesn't mean you can't re-enter with AP. All right. So yeah, use customs officers. So that's of course as attorney, I have to tell you, which thank you for your question. Immigration can this customs officer deny your entry? Based on that fact alone, likely not, because you have AP and it's valid, and you don't have, assuming you don't have any criminal history. But technically, customs officers has wide discretion; they can deny anyone, and they don't have to tell you. They don't tell you jack squat. They don't tell you why they denied you, right? But fortunately, knock on wood, every client that we have that doesn't have any criminal history that has AP has been able to leave and come back. All right, so hopefully that helps. Oh, you say, how do stateless people get green card according to new USCIS report? Okay. Yeah, let us know. I mean, yeah, there is a new annual, every year the USCIS does issue out a report. I think that came out about a month ago or so. Look forward to that conversation. Okay. Um, but probably in your scenario, you would need to, um, okay, one moment. All right, guys, I appreciate it. Thank you so much for your questions. I just got to run to the other meeting. I see I've run out my time. Click the screen on TikTok. I greatly appreciate it. And give us a call right up here. Okay, if you have any questions, or go to greencardguys.com. Thank you so much. And y'all have a wonderful day. See y'all tomorrow.